Mr Gordon says, all right, well, let's talk about the AW Workplace Reform Association account. That account, as you've said, is an account which was the account belonging to an incorporated association by the same name, which was incorporated by Slater and Gordon on Wilson's instructions following your advice to him, which you described earlier, and you say that's right. And then the question is, that happened in or about mid-92. Answer, that's right. Now, you're talking here about a bank account, correct?
This document, as you would be familiar, Mr Stolger, records a discussion, quite a lengthy discussion about the AWU Workplace Reform Association.
Yes.
I think Mr Gordon might have been using the terminology account because we'd been talking about election funds. I had no knowledge at that time, or knowledge at any time, about the banking arrangements of the Workplace Reform Association.
Well, isn't he saying to you, he says, that account, as you said, is an account which was the account belonging to an incorporated association by the same name, which was incorporated by Slater and Gordon at Wilson's, on Wilson's instructions. And he's referring to an account quite separate from the association, correct?
When you look across this discussion with Mr Gordon and Mr Shaw, there's a discussion about the Workplace Reform Association. There's a discussion then about bank accounts at the Victorian branch of the AWU. I think Mr Gordon used the term account following that discussion. I didn't know anything about the banking arrangements of the AWU Workplace Reform Association.
You understood that the association was setting up an account?
I understood
at
that...
the time, I mean.
Mr Stolger, I understood that it was the desire of Mr Wilson and others involved in the association to have an association, to be a team that would run together for union elections and to have an account into which they would bank monies that they had fundraised for that purpose, yes.
And the account to which Mr Gordon is making reference on page 137 is that very bank account, is it not?
He's obviously referring to the discussion before, yes. But if your question to me is, and I may be misunderstanding you, Mr Stolger, and if I am, I apologise, but if your discussion to me is, did I have any knowledge of particular accounts operated by the AWU Workplace Reform Association, no, I did not.
Well, I'm not asking if you knew the account number, but the fact is that you knew that it had set up an account and was operating an account under the same name as the association?
I knew at the time that I provided legal advice on the incorporation that there was an intention to set up an account.
Well, you certainly understood as at 11 September that the account had been set up because Mr Gordon makes reference to it and then you say that's right.
Mr Stolger, I'm not sure I can take it further for you than I have. Right. This was a discussion where we talked about the Australian Workers' Union Workplace Reform Association, and in other sections of the discussion I make it perfectly clear that I had no knowledge of any of the banking arrangements of the Workplace Reform Association or any knowledge of its accounts.
When do you say you became aware that in fact an account had been set up by the association?
I did not become aware that an account had been set up by the association.
Well, you know as you sit here today that one was set up, I take it?
In time sequence, sorry, because you've just jumped from this discussion in 1995 to the present day.
Yes.
In time sequence, I provided legal advice, as has been discussed here and is in my principal statement. I provided legal advice. I then had no further contact with the work of the association or its banking arrangements. Obviously, given the extensive publicity and inquiry into these matters since, I've become aware in the years since that the Australian Workers' Union Workplace Reform Association had an account.
If you go back to 137, Mr Gordon... Page 7.
Thank you.
Yes, you've got it.
Can I have the...
You go on to, Mr Gordon goes on to say that Slater and Gordon had drafted some model rules and the like, submitted those rules to the relevant Western Australian government authority, letter back, might be a trade union, therefore ineligible for incorporation, and we prepared a response. And then you say, well, he's asking you about dates, and you say, I wouldn't want to be held to those dates without looking at the file, but whatever dates the file shows are the right dates. Now, to which file were you referring?
I'm referring to the file about the incorporation of the Workplace Reform Association.
Did you open a file in relation to that matter?
I had a file, a manila folder with documents in it, which would have been labelled Australian Workers Union Workplace Reform Association or something like that, which would have been held in the filing cabinets that were on the ground floor at Slater and Gordon where the industrial unit worked.
So you collated the documents in a file and put the file in the filing cabinet but didn't open the file on the system. Is that the position?
Yes, that's correct.
Were there any other files in the filing cabinet that weren't open on the system?
Yes.
You accept that if substantive work's done in relation to a matter, it would be appropriate to open a file on the system?
To just explain the context here,
yes.
In the days I worked at Slater and Gordon, which obviously is a very long time ago, it was a much smaller firm than it is now. Its business model at the time was that it was heavily reliant on plaintiff personal injury work. The laws of plaintiff personal injury work were quite different than they are today. The purpose of the industrial unit was to do industrial work for trade union clients and for employees, and obviously to earn fees in doing so. But it was a part of the purpose of having the industrial unit that Slater and Gordon would form bonds with trade unions so that trade unions would refer their plaintiff personal injury work. As a result, it was common to do work without fees for trade unions and trade union officials.
It may have been common to do some work, but where you're engaging in substantive work of the kind that Mr Gordon describes on the page I just took you to, a file ought to have been opened, correct?
It was always a judgment call about whether or not one would open a file for work that you were not going to charge a fee. There were various arrangements for doing that. You would keep file notes and they may be put on your personal file. So I had a file in the filing cabinet called JEG General for our trade, JEG being my initials. For trade union clients, we had files in the filing cabinet that we would collect file notes on telephone advice and minor matters. So you might have the Municipal Employees Union-General file. Then if you performed work where you put it in a folder, you'd make a judgment call about whether or not that should be opened as a file on the system. A clear dividing line was the dimensions of the work and most certainly whether or not any disbursements were raised.
But this was a substantial job, you accept that?
Oh, no, I don't.
You don't accept that?
No, this would have been a job that took me in total, I don't recall specifically, but I would have said in the order of 3, 4, 5 hours work at most.
It was more substantial than just bits of free work or telephone advices and that sort of thing?
Mr Stolger, I can assure you I did more substantial jobs than this for free for trade unions during my days at Slater and Gordon.
And it really ought to have been open on the system, you accept that?
Look, when I was discussing this matter with Mr Shaw and Mr Gordon in 1995, I indicated to them that with the benefit of hindsight, maybe it would have been better to have opened it on the system. But I did do more substantial free work for trade union clients and trade union officials than this particular job.
If you go to page 151, there's the passage of the transcript of the interview to which you may be making reference.
Page 21. Thank you, Commissioner. We've now been provided with the... Good.
And about halfway through the page, it's stated this was a more you say this was a more substantial job than that and really ought to have been opened on the system.
Yes, I just referred to that passage.
Yes. Now, was there a Mr. Lang working in the office at the time?
Yes, Mr. Lang was employed at Slater and Gordon as
Did
a
he
solicitor.
Did he have a particular expertise in incorporated associations?
Yes, he did.
The point in any event is that Mr. Wilson was the client, so far as you were concerned.
That's correct.
And you say in your statement in the passage to which you made...
Mr. Wilson and Mr. Blewett.
All right, well, the person who was predominantly in discussions with you was Mr. Wilson.
Mr. Wilson and Mr. Blewett. Obviously, Mr. Blewett was playing a role in this incorporation. He's the signatory to the documents.
My question was, the person predominantly communicating with you in relation to this matter was Mr. Wilson, is that right?
I had communications with both Mr. Wilson and Mr. Blewett. I would have had more communications with Mr. Wilson. That's correct.
You accept that Mr. Wilson was the person who was predominantly communicating with you in relation to this matter?
Well, I was communicating with both of them, but I was more regularly in contact with Mr. Wilson, that's true.